First of all, I have to start by saying that supervision in the paper and in my discussion and otherwise can be used as a more general label. Supervision and oversight are both regulatory functions. In the sense that they kind of address the topic of regulatory compliance. But supervision as a regulatory function is composed of several different activities, such as, for instance, as I was saying, licensing or authorization of businesses, for instance, credit institutions. Then you have the supervision stricto sensu in Latin, or the narrower supervision, which is actually the on-site supervision. And here comes oversight, because oversight is some form of an on-site assessment, continuous assessment of the regulatory compliance and the efficiency of the systems, of the payment systems, and you assess them against predetermined standards, which are determined by the ECB's oversight policy framework. And then supervision also comprises crisis management and sanctioning. Oversight is just one of the narrower functions, in that sense, can be understood as a narrower function of the regulatory activity of supervision. Okay? As for the ECB, it has both supervisory and oversight competences. Supervision is much more used when you address credit institutions, so it has supervisory powers against credit institutions because it can manage the crisis, it can sanction also. But it also has oversight competences. Well, this is kind of a fluid area because, as I was talking in the lecture. Now, not only does it monitor against predetermined standards, so oversees the payment infrastructures, but it can now also sanction and impose corrective measures. So, kind of a sanctioning function as well. So what we see here is actually not only the empowerment of the supranational layer in the governance of oversight, but also kind of the expansion of the activities within the oversight competence of the ECB.
And
well, you have to understand that the centralization which is happening now on the supranational level is not something that is only happening in the field of payment systems. Firstly, it happened in the field of the banking sector. So this was the most notable aspect and the most criticized one and the most analyzed one. You had the banking union, and then we now have the banking union, and then you had the extraction of the supervisory function in the single supervisory mechanism of the ECB. So this was really a contested issue by the member states, especially of the euro area, and especially by member states of the European Union with a strong regulatory identity. So those which have really a great expertise in the issues of supervision. By other states, I think centralization by other, I mean those states perhaps that are such as my country, you know, a transition economy and a newer member state. For them, this centralization at the supranational level should not be that bad, because actually it gives them perhaps more public confidence in the banking sector or in the sector of payment systems, or whichever sector we are talking about. Overall, personally, if I may say, as we were talking a little bit yesterday, I'm not that really favorable of this great supranational layer and the centralization of all the central banking powers within the European Central Bank. For now, as the current situation is, the European Central Bank is gaining ever more powers. So it is taking more from the policy capacity, as I explained it yesterday, from the national central banks. And national central banks are becoming, well, something like an administrative outpost just for implementing various policies which are dictated from the supranational level. So it is going to continue to be a very contested field of competences between the member states. But I don't think that the European Union will let go of such a trend. This is an imperative. This is something that has become a regulatory paradigm, and I think it's going to stay here for the future.
Now, briefly, what recommendations would you have for the ECB
in regards of
the payment system?
In regards to the payment system, well, firstly, as I said, I think that one of the major and notable steps forward was that it finally exercised its statutory powers, its regulatory powers. It finally intervened through a regulation in 2014 in the area of the payment system. Before that, when you looked at the documents, you were not really sure whether it will ever exercise such a power, and whether this power will be exercised in the area of large value or retail payment systems, which were more important or systemically significant for the ECB. Now you can see that the ECB really wants to regulate even large value and retail payment systems. But my recommendation perhaps would be to focus more on the retail payment systems. The large value ones are, for now, they're set, but the retail payment system, especially with the SEPA project, who will be hopefully fully operational for the European economic area by October 2016, I think, really calls for a stronger intervention of the ECB in order to form, common standards and greater legal convergence between the member states, especially those which are not part of the euro area, and actually to form a SEPA-friendly legal environment in those states. So perhaps a more pronounced and direct role in the segment of retail payments.
Thank you.
Thank you for your questions.
Thank you.
Thank you.
So the example of PayPal actually is a very interesting one, and at the same complex example, because actually what we can see is that many different laws apply here. So PayPal actually, as a company, offers a relatively standardized payment service in more than 200 countries across the world, and possibly it would wish to offer very standardized payment service. However, one of the reasons it cannot is actually the impact of law and of different domestic law. So PayPal is a company that was established in United States, in California, and as such it is subject to California and United States law. This is and also for whatever payments are made within the United States, it's governed by the US law and then possibly applicable states law. When it comes to the European Union, however, PayPal actually established a branch in Ireland, which is then an Irish company and also European Union company. So this company as such is governed by Irish law and by European Union law. It was so this is the source of law for the company itself. But then, of course, the question is what are the sources? What is the law governing the payment relations under PayPal? And also, what is important here, because the way PayPal actually works is that users of PayPal or open an account with PayPal and therefore establish a relationship with PayPal, a contractual relationship. So let's say it's me and you, and I'm going to pay you for some goods. I come from Poland, so let's say I'm based in Poland, you're based here in Italy. So when I open a bank account with PayPal, the relationship between me and PayPal is going to be governed by Polish law. So whatever whatever rights and obligations I have towards PayPal and PayPal towards me, they are going to be governed by Polish law. By Polish law. So first comes the relationship between me and PayPal, because I have an account, and the question is the PayPal really obliged to make those money? So I can transfer some money through a bank account, for instance, to PayPal. Is the PayPal obliged to make those money available then to me all of the time? In what way, etc. These are all questions that are governed by the contract between me and PayPal, and then this contract is governed by Polish law. If I establish as a Polish resident a contractual personal relationship with PayPal. Then you come in the picture. So in order for the transaction between the two of us to take place, you also need to open an account with PayPal. So you are now resident in Italy. So when you open an account with PayPal, you need to specify the country of your residence. You specify it's Italy. So the contract between you and PayPal is going to be governed by Italian law, not by Polish law. And so this is the relations here is PayPal. This is the relation between me, PayPal, and PayPal and you. Now comes the question. So ultimately, I am paying you for something. You send me a book and I'm making a payment. The question is then, which law is going to be applicable to that relation between me and you? So, and this is actually specified in the PayPal rules, which says that it's always the law of the person who is receiving the payment. So, if you're receiving the payment, it's the law. It's your
the Italian law.
Yes, it's Italian law that is going to be applicable to the transaction. So, but then if the transaction between us would go in a different way, it would be Polish law that would be actually applicable to the transaction. So the situation is, as you can see, complex, and there is no single set of rules. I mean, there are PayPal rules, contractual rules that apply, but apart from this, if we come from different countries, there are different jurisdictions that are going to be applicable to the relation.
Well, so anonymity becomes very relevant when one thinks of the applicability basically of criminal law. Because one of the problems is when there is perpetration of a crime through bitcoins or on a Bitcoin platform, and there we have the problem of identifying the responsible subjects. So from that point of view, there's a slowing down in the enforcement process, I would say, okay, especially of criminal law. When we speak of the transactions taking place between, like on a peer-to-peer basis for other reasons, without hypothetically a crime being committed or an illegal activity, I wouldn't say it slows down the law so much, rather as makes it, well, it is either a neutral element, anonymity, or it becomes rather attractive because it may be a way to circumvent, for example, anti-laundering regulations or tax evasion, because we have a transaction in money that cannot be traced to an owner. So I think it renders it very attractive and maybe somehow promotes speed rather than slowing down. It slows down the enforcement.
Okay. And
I think, that's really confining a lot in the success, future continuing success of Bitcoins, and that's actually something that's really put under a big question mark. So according to some observers, the Bitcoin is bound to explode. It's like a bubble. It's one of the next bubbles that we will assist. In other cases, regulation may put handcuffs onto the Bitcoin as such and render it something that will only be used for very small, specific transactions. And then there will be other mutant forms that will continue circulating for the off-the-record transactions. Currently, I don't have the impression that it could be so relevant in a global economy, but it may bring the risk that widely accepted alternative currencies or complementary currencies bring. So if it does become really competitive with an official fiat currency, then the issue may arise. But it has to reach that point, which currently I don't think has yet been achieved as such.
But is it possible to reach that point given that they are finished?
Well, hypothetically, yes, but we have to see if regulation is put into place. Will the growth continue? Will the great growth continue? Because now it's flourishing because it's kind of in the middle of a legal vacuum. In the moment, and if a regulation is placed, will they still be so attractive?
Okay.
Maybe I have one question. With the value function of bitcoins, because they maintain the whole value after some period of time. There's some kept and they hold value after some. How is this important for their growth, their maintenance?
So, in the cases in which they have kept their value, this associates their function to an investment that one makes, a store of value, an investment, a rare asset that one buys and keeps, and then uses it, sells it, if their request really grows. If at a certain point bitcoins are no longer attractive, then this may be an investment that will prove to be not fruitful. So there's a double risk to this, the moment in which you decide to somehow invest in the future use, imagining that they're finite. The assumption, of course, they are finite, is that there will still be a request for them. Because otherwise, if you take away that assumption, then it no longer becomes so attractive.
Thank you.
You're welcome, thank you.